explicit sexual content. And to that, we applaud them. Incitement to violence. Several sites have been taken down because they were calls to jihad. We applaud them for that. But viewpoint that is objectionable or offensive or denominated as hate speech, which goes to something that is countercultural or something that is simply deemed to be offensive in our current cultural parlance, should be the province of a robust value of free speech. Now, the other thing I was going to add about this kind of a paradigm is that having worked with a newspaper as a student reporter when I was in college, in addition to working on the college newspaper, I remember the printing press being in the basement. I don't know if that's true anymore with the newspapers, but in the old days, they had the printing press in the bottom and the editorial offices were at the top. Well, that's not just a metaphor. I think that's a reality. Editorial power, editorial rights, implicit in, let's say, freedom of the press, presumes that you're making editorial judgments as an editor. I don't look at Apple, I don't look at Yahoo, and I don't look at Google as being of the same kind of editorial offices as an editor of a newspaper. There is some content control that makes them more than just a printing press. But there's certainly less than the traditional editor in a newspaper. Now, how we deal with this hybrid, I'm not sure. But I do believe they're more of a printing press, a platform, than they are of an editor's office. And how we work that into our paradigm, I'm not quite sure. But I offer that as a metaphor and for enlightenment from some of our other panelists.
Ryan, what's your reaction to the proposal that Craig set forth just now and in the paper, True Liberty in the New Internet Age? I mean, you know, invoking Supreme Court jurisprudence with all of its ambiguities, but it has some bedrock principles, no viewpoint discrimination, things of that nature. Can it work? Is it a good idea? Does it make sense? What are your thoughts?
It's a good idea. I don't know how far along I would go with it, only because, I mean, I think the distinction he just made between, they're somewhere between the editor and the printing press is a really helpful distinction. And so what I wouldn't want to do is to say that anyone who's going to be a new media company or who aspires to having a large share of the market as a new media company, or anyone who's going to be an internet service provider has to be an all-comers new media policy or an all-comers internet service provider. I think we should have a plurality there. And so there will be some companies that will operate more like the printing press. And they're like, look, what our value is free speech. And so we don't care what's being said. We just want to provide a platform for people to communicate. It seems like Twitter, within your report, is the one that is closest to that. But I went other places. I mean, think of the case of, it was one of the online dating sites. I think it was eHarmony. And it was founded by a Christian psychologist. And he wanted to set up men with women, women with men. And then he got sued because he wasn't allowing for same-sex dating. And so you could say this is something of a new media platform. And it wasn't having freedom of speech or free association principle governing it. I think it's fine if there's a company like eHarmony that just wants to do male-female datings, and it's fine if there are other companies that want to have male-female, male-male, female-female, group dating, group marriage, whatever. I want to create space as much as possible for lots of different companies to flourish. And so where I can go so far with Craig and where I kind of start being resistant is not wanting to fit, because the one-size-fits-all policy, it works well for the state because the state has coercive power. Right. And so the reason we want the First Amendment where Congress can make no law is because they can actually make law with penalties, whereas the most that these new media companies can do is create incentives, economic incentives, market incentives. So I'll leave it there.
I didn't want to cut you off.
Oh, no, that's fine, yeah.
Okay, you're ending anyway. Okay. Yeah. So actually, there's a couple of points implicit in what he's saying and what Craig was saying as well, which is the new media marketplace is very dynamic. It's very competitive. So I've been on the FCC almost 6 years, which seems impossible to me. It seems like just about 3 or 4 months. But my hair was black when I started. When I started on June the 1st, 2006, you know, Facebook was really just a startup and nobody had ever heard of it. A tablet was what you took, you know, to take your vitamins in the morning. You know, Twitter and, you know, tweeting and all that wasn't in the, well, it was in the vocabulary, but it means different things. What birds do, exactly. So I remember meeting early on in 2006 with the senior executives of Google, And one of the questions I asked them was, well, who's going to be the next Google? And they said, well, we want to be the next Google. Well, little do they know that Facebook was going to be the next Google, right? And that's their biggest competitive threat. Google is now a mature incumbent. And just in, the span of a decade, basically, that has happened. There is someone somewhere with a laptop inventing the next Google or the next Facebook or the next Twitter. We don't know what that's going to be, but it's going to be disruptive in a positive way. So I think that is actually very good news for liberty and choice in general. I also think there are going to be more and more powerful tools for parents, for instance, to protect children on the net. Of course, in our household, I have 3 young kids, and so we have one broadband connection, and it's in a place where we can see everybody. And we also ration electronics, so no electronics on school nights unless it's for school purposes and all the rest. But we can see what's going on. So that's the first and last line of defense. I think it's important to say. But with this dynamic and competitive marketplace, there will be more choices out there. And I think that's only a good thing. So we hear about monopolies or dominance, which I don't know if you meant it in the sort of legal context. That can have that's a legal term of art in terms of antitrust. But they will be threatened. There will be a new king or kings or queens someday, and that day will come soon. And I think actually that's a very good thing.
Craig.
I'd like to follow up on that because I read recently in, I think it was Bloomberg Business, a recent article within the last 2 weeks, an interview with Larry Page, the new CEO for Google, and he was complaining vociferously about being pinned in on all sides by their competitors. They said, on one side, we've got Apple, and they are going to all these wireless platforms, and people are leaving the stand-up computer, which was, of course, the basis for Google's tremendous success. And then on the other side, we've got Facebook with their social networking, and we're being clobbered on both sides. And that may or may not be the case. And that battle of a few titans does mean that there is some competitive market reality going on. The problem I have is, as we look at the reality of the competition, and it is fierce, no question about it, but it's fierce among several giants. All of the new media giants that we analyzed, and I don't believe there's collusion, by the way, at all between them in terms of their user policies. Lawyers will very often use specimen contract language from other companies, and it doesn't indicate collusion, and it also doesn't indicate laziness, just may indicate that someone else has got a better idea in terms of language for your guidelines. But their guidelines are very similar. They almost look like they were drafted by the same lawyer, and every one of them bans hate speech. Now, if the principles of free market really worked, wouldn't we expect one of them to break free and say, we're the really open free speech web platform? The other guys aren't. We wear the white hats, they don't. Now, I'm waiting for that to happen, and maybe it's just a matter of time lapse that we haven't waited long enough to have a company become more prominent in terms of free speech values, and the time will come, but how much time do we afford for that reality to happen? So that's my question.
Well, in the meantime, could you, when I say set up, it makes it sound like an external party is doing it, but could you create some sort of voluntary compliance mechanism or system? I mean, really, how feasible would that be to get these folks on the same page? Setting aside the pressure that competition applies, but if you approach them now and ask them to do something voluntarily, in your judgment, is it feasible? And Craig, too, did you think that is there a realistic chance that these new media companies would sign up for something saying, you know what, you're right, this is an American value, respecting freedom of expression, the circumstances in which we've not respected that value were mistakes. I mean, you may not go that far, but you see what I'm saying. My question is about the feasibility of this kind of voluntary compliance structure. Commissioner McDowell.
Well, no, I was just going to say that actually Craig might be onto something here. He could start it himself. Instead of calling it partial net, he could call it impartial net. But no, I think the great thing about the internet is that it is flat. The barriers to entry are low, and so you don't know what's going to happen tomorrow, and that's the virtue and the vice of it. There's a harm that can come with that, but there's also a lot of good, and we hope the good outweighs the harm. But Yeah, I think industry codes of conduct can be very constructive. Self-governance, the beauty of that is that if it's truly self-governance and there's no state power involved, you can withdraw from it. And in a diffuse, non-hierarchical marketplace such as the internet, that can be very beneficial.
Well, and your comment, Commissioner, about codes of conduct rings a bell, because before I started handling First Amendment litigation, for a number of years I did products liability cases, medical malpractice, and these voluntary codes, whether it's the fire code of the Fire Association or Automobile Manufacturers Association, these codes don't have the force of law, but they have tremendous moral influence and business decision-making influence over these manufacturing companies in terms of safety codes. So it has been, there's a proven track record for certain codes of conduct with regard to those kinds of objective areas like safety. Free speech and viewpoint protection is a little bit more amorphous, unfortunately, than engineering concepts to keep our automobiles safe, or having fire codes that keep houses from burning down. I think it's a little bit more difficult to manufacture some kind of a uniform code, but I think, as you indicate, it hasn't been tried, and been found wanting. It simply hasn't been tried yet. So.
And Greg, one thing, I mean, I just want to circle back to one thing to stress it again. When we look at the examples that were in the report, and I've actually got another example that's very similar, and this hasn't been made public yet, but I know of a company, a major Christian ministry in this country, who literally, I think I would call it some sort of database terrorism. That the group that they had their database with had a small number of radical individuals go to the CEO of that company and say, we're going to sabotage these people if you don't pull the account, because their position is that marriage is a man and a woman. They breached their contract. They pulled their data midstream. Anybody who's tried to get a database management system in this arena knows how none of them work. So to find one that even kind of works is a major feat. You know, because this is maybe more of a Christian ministry, they wouldn't do what I would have wanted them to do, which is file a lawsuit. Breach of contract, hundreds of thousands of dollars were cost. And the CEO of the company should have said, you're fired, you know, but they didn't. And so in addition to the ones I've seen that. Now, one of the things I would point out about this that I find disturbing, and this is what really clicked in me as a guy who's spent my whole career trying to defend the First Amendment and then realizing I could win all these cases under the First Amendment and still lose everything I'm really after if we lose the entire, you know, communication systems that are going on for the marketplace of ideas. That we've got to realize that what is the core of a number of these? It's one example. It's marriage is a man and a woman, the battle about, you know, gay marriage versus traditional marriage. This is, as we've seen publicly, this is a 50-50 issue, or, I mean, it's pretty even. And we're having censorship over something that, I mean, a huge swath of the country thinks is perfectly fine. I find that very disturbing. The Google example of why the controversy was, from what everybody's heard, really this issue. That's why they pulled from all the churches and religious groups. The situation with the Manhattan Declaration, same issue. The example I gave, and a number of others. So what I find disturbing about it is it's not even the very unpopular thought, the 10%er. It's things that are maybe even majority beliefs that can be completely banned throughout our marketplace of ideas, and we can't even use the Constitution to do anything about it. So it really is important that we find a solution, a self-regulatory solution, you know, whatever that solution is, and to address it now before, you know, we get ourselves into a situation where we've really lost our country because of something that really the Constitution may not apply to.
Isn't there sort of a deeper sort of degradation of First Amendment values in the popular culture? I mean, think about those folks who approached the CEO of the company and said, we're going to sabotage the database because we disagree. I mean, there's something going on there that's deeply troubling about their commitment to First Amendment values, right? Their commitment to the marketplace of ideas. So I think we have sort of a cultural problem that's behind this. And piggybacking on that point, I mean, Craig invoked the common sense distinction in free speech law between sort of expression of political and religious ideas, which is protected, and say child pornography. I think the problem is that though the line between those two categories is in the eye of the beholder, right? We now have people who believe that the expression of the view that marriage is a man and a woman or something like that is as offensive as child pornography. I think that's the point that you were sort of making.
It's worse. It's you know, we were all of us who do religious liberty work, sort of the religion as pornography. That's one of the things that Justice Scalia and others mentioned. This is worse than that. Their pornography clients, they wouldn't do this to, but they would do it to a religious client that had a belief that marriage is a man and a woman. So literally, in their world, pornography is more protected because they're willing to take their money, but they're willing to forego and to actually sabotage the religious group because they have a biblical belief on marriage.
Ryan, is this consistent with what your sort of perspective on what's going on now is sort of the diminution of sort of national agreement about, well, you know, I may disagree with you, but I'm going to let you say it. And there's an increasing number of people who are saying, you know what, you're wrong, therefore I'm going to... And
it's on this issue in particular. So I should mention that with Robert George, I'm a co-author of an article in the Harvard Journal of Law and Public Policy titled, What is Marriage? And then we've turned this into a book that's coming out this summer with Encounter Books, and it has a subtitle. So the title is What is Marriage? The subtitle is Man and Woman, a Defense. And this is the issue on which my friends from high school, my friends from college, they don't understand what happened to me. They look at me like I have two heads. When I link to things on my Facebook page, so last week, in the aftermath of the North Carolina vote and then President Obama's statement on marriage, I linked to various things that I wrote for National Review on the issue. And my Facebook page just lit up, not with my friends supporting me, but with my friends who think I'm a bigot. And so I'm not surprised that the censorship concerns and the First Amendment concerns that the Milton Project is expressing all seem to touch upon this issue. Because I think this is the issue in our political culture right now that's most divisive. And I think even if though we're a 50-50 nation, I think we're much more polarized when it comes to elite versus everyday opinion. And so the people who control the media, who control business, who control the hallways of power very much are in favor of same-sex marriage, and they have a hard time understanding why someone couldn't be in favor of it. It just seems like sheer bigotry to them, and you have a lot less tolerance for the free speech values of a bigot. And I mean, and that's just something that has historically been the case. Americans aren't very tolerant of bigotry. And so if the issue gets framed that way, and if it comes to be understood that way, especially as it has among the shapers of public opinion, the elites, I don't know how we can come to a good solution on this through a free speech mechanism rather than the actual substance of the question. And the same thing is true, I think, for religious liberty. I think if we lose the actual substance of the marriage debate, we won't have the right to be a religious bigot. In the same way that Bob Jones University lost its tax-exempt status over its policy on interracial dating and marriage. So I just think there's a big train wreck coming within the next 5 to 10 years.
Ryan, let me follow up on that. Some of us who have a little bit more gray hair than you do have a little bit longer perspective on some of these free speech issues. In the 60s, I was at University of Wisconsin when the doors were shut by radical groups. I couldn't get out of my psychology class, and next thing I knew, a National Guardsman with rifles were on the other side of the door, and we were trapped in buildings. Now, that wasn't a form of free speech. That was a form of violence. But there were forms of free speech that were outrageous and pretty robust. And the cry at that time was, well, we shouldn't be censored over the issue of the war in Vietnam. Then the 70s came, and then the frontier seemed to be, the cutting edge seemed to be pro-life versus pro-abortion speech, and primarily reducing the zones of speech for pro-lifers and where we could speak and when we could speak. And then it seemed to morph into the issue, and I don't mean to diminish the importance of the marriage question. What I'm saying is, in terms of context, it always has to do with whatever the cutting edge is. And while we do mention gay rights issues in our white paper, this is not a gay rights issue, it's not an abortion issue, it's a free speech issue. It depends on what the cutting edge cultural issue happens to be that's driving it. I remember what Robert Bork said when he lost his nomination to the Supreme Court. He said he always thought being on the cutting edge would be an exciting thing to be. He said, but then he's learned that it really depends on whether you're the knife or you're the bologna. So the cutting edge right now are those who want to take a biblical view of marriage and find themselves at the other end of some of these extreme forces that would shut down speech. But I guess my perspective is we need to fight for free speech, regardless of what the cutting-edge motivation is that's attempting to close it down. Now, the difference is it's not government coming in and saying these protests at the Democratic Convention are disturbing public peace. It is private communication platforms that are large, that have, frankly, the budgets of a small island republic. So, and again, I'm not suggesting federal regulation or legislation. I'm saying, how do we get the attention of these companies? How do we increase competition? How do we make a more vibrant marketplace so that someone comes out wearing a white hat and so the others will feel compelled to do so also?
So I suspect when these new internet companies, do something like take the Manhattan Declaration off the App Store of Apple, they would say that what they're doing is they are protecting their users from speech that's offensive or objectionable, characterize it as hate speech, and say that they have an obligation as a steward of the resource that they possess, right, to protect people from hate speech. So what should internet companies do with stuff that they call hate speech, or which is genuinely hate speech, hateful speech? How should they do that? I know that you guys were a law review article in Boston University in 2011, their law review, and the authors of that suggested certain means for internet companies to sort of deal with offensive speech, objectionable speech, hate speech, things like just taking the content down or blocking the user from posting further speech, providing an opportunity for response. Just a question for the panel. What do you think these internet companies should do when they're confronted with something that's objectionable, offensive, that might fall within this mysterious category called hate speech?
Hate speech is just a weapon ultimately for censorship. It's a very vague term, and it'll be used to censor whatever someone doesn't like. I really think it's kind of an avoidance of the issue. It's just basically saying, I will stop any speech I don't like. So it needs to be replaced. For instance, speech that incites violence or that encourages violence, that's much more specific. And much of the hate speech examples in the law review article you're talking about are almost all incitement to violence. Mm-hmm. So I think they're intentionally use words like that to have no accountability and to be able to do whatever they want, which means censor people they disagree with. So I just think we've got to use better terms, and that's why I think some sort of policy that says, here's where the line is. Again, we've got a lot of cases that have helped us think through these things, but I think violence is a great starting point for something much more specific that's not broad and doesn't basically say we can use our discretion to ban any speech that we think is wrong because it disagrees with my position, which is how hate speech is being used now.
Craig, are you more optimistic about the capacity of, say, an internet service provider or a Google or a Facebook to define narrowly the category of hate speech and then do appropriate things about it?
It's interesting. We took a look at Comcast and Verizon and AT&T, three very large internet service providers, and while their policies are very much like the new media companies like Facebook and Google and MySpace, Twitter, their practices show an absence of content viewpoint-based discrimination. We couldn't find any examples, really, among the big internet service providers. So what that means, I'm not sure, but they're a gatekeeper. I mean, again, I think in terms of physical metaphors, they seem to be the drawbridge to get into the internet. But the new media companies are the actual platforms. They're the public parks. They're the public forums. So it's not a gate, it's a forum that is tremendously effective and that a larger number of people are using. So what's the possibility that we're going to get their attention? I'm a little bit skeptical at this point that short of a higher profile of this issue, that they're going to have an aha phenomena and come to a more vibrant respect for free speech values on their own. What it will take to bring them to task, to analyze the problem, and then come forward with more, robust free speech policies, I'm not sure. I do know that Capitol Hill can provide perhaps an opportunity for a bully pulpit. We're not asking for legislation or regulation. We are asking for dialogue. I'm learning things today because this is a moving target with a lot of moving parts, and it's a tremendously complicated issue. As a matter of fact, when we approached Heritage Foundation, an organization that we have tremendous respect for, about getting involved in this issue, I realized that this issue about free market and free speech cut across, I think, 5 different departments in Heritage Foundation. It's that complicated, and yet, as Kelly's pointed out, it's that important.
Yeah, Commissioner McDowell, I know it's not your job to put yourself in the shoes of an internet service provider company, but can you imagine, say, having a policy under which you would flag offensive speech, that you as the company would sort of monitor what's being sort of pushed out through your facility, as it were, and saying, warning sign to the users of this? I mean, would that be a prudent thing for them to do? Is it a feasible thing for them to do? What are your thoughts on that?
This is an argument that came up in support, actually, of net neutrality regulation, that last mile broadband providers, ISPs, somehow had an incentive to manipulate content and applications, or censor, as it was being called, speech, and not in the strict legal term of censor, of course, because it's a private platform. I think ultimately that would be very bad for business. An internet service provider really is going to make more money the more traffic they have going over their network, provided they have the ability to then expand their network. And we'll omit a discussion of wireless spectrum policy for today. But it would be bad for business. It would also be, just as a practical matter, impossible. I mean, we can't count the number of bits flying across any internet service provider's networks at any given time.